Good morning, all. This pre-trial review is in the matter of CFI 031-2017 and is being held by way of video conferencing before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Onoma. Lead counsel is Mr. Faisal Osman. The defendant is represented by Altamirian Company, and lead counsel is Mr. Daniel McCarthy. Thank you, Your Honour.
Yes, well, good morning. I understand there are three matters to be dealt with today. The first is vacating the trial. The second is the question of judgment for the claimant on admission, and the third is the question of costs. Before I embark upon those matters, does that cover it, or are there any other matters that the parties consider we should deal with? Mr. Osman?
No, you want to have it precisely that.
And is it McCready? Did I get your name correct?
McCarthy.
McCarthy. Yes, Mr. McCarthy. Are there any other matters?
Your Honour, have you received our note that was sent this morning?
Yes, I have.
Yes, we would want to add. We would want to say something about the circumstances as to how this hearing has come on, in particular, what's happened in the last 24 hours. So, insofar as that's not covered in that agenda, we'd like to say something about that as well.
Well, I think it will be, but certainly you won't be cut out. Let us deal then with the first topic on my agenda, which is vacating the trial dates.
Yes.
I assume, is it common ground that the trial should be vacated? Mr. Osman?
It's certainly, that's my understanding, it's common ground.
Mr. McCarthy?
Yes.
All right. That will be done. The second question then is entry of judgment for the claimant. Now, the claimant has provided a draft order. Mr. McCarthy, leaving aside for a moment the form of the order, does the defendant agree that judgment should be entered for the claimant?
As you say, it depends on the precise terms.
Yes. Yes, well, that's the next matter I'll come to if we've got to the common ground that there is to be judgment. All right, let me then come to the form of the order. Now, Mr. Osman, you have, and you provided a hearing bundle as well as a draft order. I assume it's the same draft order in both.
Yes.
Now, that provides in order 1, the defendant has admitted that the personal guarantee dated 10 December 2014 purportedly entered between him and the bank was signed by another person using the claimant's name and signature. Now, it seems to me that that is an appropriate form of order with this amendment. I don't think it's appropriate to recite that the bank, to declare that the bank has admitted that. A declaration is a declaration of the legal effect. The fact that you get the So the order ought to be to the effect that the document titled Personal Guarantee dated 10 December 2014 purportedly entered into between the claimant and the defendant was not signed by the claimant, but by another person using the claimant's name and signature. The said personal guarantee is void ab initio and of no legal effect. Mr. Osman, do you want to comment on that?
No, I think that in effect all that we've done is we have omitted the defendant has admitted. Because Your Honour is completely right. It's a declaratory judgment. It's the court making a declaration. So I have no comments on that.
All right, Mr. McCarthy.
Yes, we've got comments on both the terms of the order, but also, as I've already foreshadowed, the circumstances in which we're being asked to respond to it. So I'd like to say a bit about both of those.
Well, let me take this bit at a time. I want to see if we can avoid wasting time. Are you able today to respond to the form of the order?
Well, I think we can respond as far as we can make points to say that we don't consider the wording as it in its current form properly reflects the terms of the letter, including the admissions.
Why not? You admit that the defendant, so you admit that the document purportedly entered into between the claimant and the defendant was not signed by the claimant, but by another person using the claimant's name and signature, do you not?
We accept that part of the wording, but there are several other points I'd like to make in response to the form of the order as a whole. And
I'm leaving aside the question of costs, but simply the form of the declaration.
Yes. Well,
and the order. Well, let me go a little bit further. I perhaps pay attention to the recitals. I would change it slightly. I haven't paid a lot of attention to the recitals in the draft judgment, but I think I would, in the usual form that of the court, the first recital would be upon the claimant's claim, and would then recite the terms of the claim made by the claimant, that is, upon the claimant's claim for a binding declaratory judgment that the document titled Personal Guarantee dated 10 December 2014 purportedly entered into between the claimant and the defendant was not signed by the claimant but by another person using the claimant's name and signature. Those are the words taken directly from the claim, and as the usual way the court goes, sets out the recitals in reciting the claim. I would then put as the next recital, and upon the defendant's written admission of the claimant's claim pursuant to Rule 15.1 of the rules of the DIFC courts, which again seems to me to be prior to hearing from you, Mr. McCarthy, an uncontroversial way of putting it. Thirdly, then upon the claimant's application for judgment on the defendant's admission pursuant to Rule 15.12 of the rules. And the last recital would be, and upon reading the documents filed and the evidence submitted, I would then proceed to set out the order. It is declared and ordered that, and the terms I set out earlier. Now, do you dissent from that, Mr. McCarthy?
You're right. I think what we're looking for is to have more included in the order that properly reflects how the letter and the admissions were put, and I'd like to show you the letter. So
I've read them now.
Yes.
But, all right, you can take me to it if you want.
Yeah, unfortunately, I'd not received the bundle. I think it's been shared during the course of the hearing.
Well, I'm sure you've got a copy of it. I've got access.
I've got a copy of the letter, so I can, if someone could give me the reference to where the letter is, or if you've got the letter, I can.
Well, I've got it, so you can, and I'm sure Mr. Osmond can find it.
Page 2, yes. Okay, so in terms of the letter, the first paragraph, this includes the admission as Your Honour has just recorded in the draft order. However, the following paragraph we say is important. The reason it's important is because there's a difference between the defendant having admitted that someone else signed the guarantee and the allegations, the nature of the allegations as have been put in the particulars of claim. It does not necessarily follow that by making the admission that the bank has been in any way involved in any forgery or wrongdoing. And
But
so
the order doesn't suggest, imply, or give rise to an inference that it has. It's a simple vanilla statement that it wasn't signed by the claimant. I mean, orders are quite different from reasons for judgment. Orders don't recite why people have taken these positions or what you've got to say about it. It simply sets out the order, and the order is simply that it wasn't signed by the claimant. That does not involve anything more than that. It doesn't say the bank was involved in it. It doesn't say the bank knew about it. It says nothing more than it wasn't signed by the claimant. I'm at a loss to know why the order should say anything more.
Well, Your Honour, as I say, in the particulars of claim, there was, and the claim form, as set out in the letter, uses the terminology forgery. We say that had connotations that goes beyond merely that someone else signed the document. It's suggestive of wrongdoing. If we look at the particulars of claim, there is a reservation of rights suggesting that there may be liability on the part of the bank in respect of the circumstances. And it's also been put in without prejudice correspondence, which I save us to cost correspondence, which is now on the record in the bundle. And I'd like to show that to you, just so, because I think it is important to the bank that even by way of a recital, that it's recorded that these admissions, as in the letter, were made on the basis that there was no admission of wrongdoing and no admission of liability on the part of the bank in the context of the allegations that have...
Liability what? Liability for what?
Well, for liability in any way arising out of the circumstances of the signature of the guarantee.
Well, that's not before me. I don't have a claim to that effect.
Well, perhaps I can show you the particulars of claim.
No, all right. Yes, all right. Do it.
So again, I'm afraid I can't give you the bundle reference.
Mm. Not sure.
Paragraph 57 of the, we'll take it a bit earlier in the claim back, but we can start at
all right.
Start at paragraph 22. And so this was pleaded. It's page 4 of the particulars if you have it. I'm told it's page.
Yes, go ahead.
So it's headed the forged PG.
Mm-hmm.
This reflects also in the paragraph of the claim form that's referred to in the letter, and the terminology that's used throughout of there being a forgery. And at paragraph 22, it's pleaded that the claimant never executed the personal guarantee, nor did he authorise anyone else to forge his signature. It is beyond reasonable doubt the fact that Mr. Mahmood made a false verification, and I think this is something I want to return to by reference to the without prejudice sales to cost correspondence that's now on file. So what the claimant was saying was he didn't sign the guarantee, and nor did he authorise anyone else to do so. And the implication that was being made, the case theory was that either it was Mr. Mahmood or someone at the bank, or some unknown.
Well, I'm sorry, the particulars don't say that, do they? And
well, then we go to paragraph 57. I
don't want to be rude, Mr. McCarthy, but this is sort of getting to Ouija board stuff. What was in people's minds, or I'm dealing with the case that's before me, not what you think somebody implied or meant.
Well, if we can have a look at paragraph 57, and I'd like to also show you that without one Mr. Boss, just so you can see more of the picture. Paragraph 57, the claimant reserves its right to claim compensation on and/or damages from the defendant, including for losses arising as a result of the negligence, deceit, and/or fraudulent conduct of the defendant.
Well, to the extent that you need any comfort on that, if the bank, where the claimant proceeds to enter judgment in the terms in which it seeks, I would be at a loss to know how the claimant could pursue a claim against the bank which was raised, if it was raised, in the particulars and has not been pursued in the judgment which is sought. This is the end. This is a final judgment. It's the end of the case. If there's no order for any damages or compensation for the claimant, then that's the end of it. He can't come back and have a second go.
Well, I understand that may be right, but what we're asking for, and I hope it wouldn't be too controversial, is just simply in the recital, or the order is slightly amended to reflect that the admission was made on this basis in the letter that's not currently reflected in the draft order. And I don't.
What I could do, if it gives you some comfort, Mr. McCarthy, in the recitals that I indicated, in where I'd said upon the defendant's written admission of the plaintiff's claim, I can add the words written admission by letter of, what was the date of the letter?
It's the 24th of August 2025.
Well, there you are. The order would then recite, would set out the admission, and one can, if you want, anybody in the future wants to, they can go to that letter to see what was the terms of the admission.
Yeah.
Okay.
Yes.
All right. Well, that'll be the form of the order. There will be, well, perhaps I should ask Mr. Osmond. Mr. Osmond, do you have anything to say about that slight change to the recitals which I indicated earlier? That is, the second recital would say, and upon the defendant's written admission by letter of 24 August 2025 of the claimant's claim pursuant to Rule 15.1 of the rules.
I can't argue with that. It's factual.
Thank you. All right. Well, does that conclude the question of the form of the order? Is there anything else to be said about it, Mr. McCarthy?
Your Honor, I did want to raise an issue with the form of the second paragraph of the order.
Yes.
Now, that's in terms that the personal guarantee is not null and void ab initio in the draft, and you've amended that slightly.
I prefer to say that the guarantee is void ab initio and of no legal effect.
Yes. Our position on that is that it doesn't necessarily follow from the admission made in the 24th of August letter, 2025, in the 24th of August letter, that the personal guarantee was void and ab initio.
Well, if that's so, then I think the case has to go to trial, Mr. McCarthy.
Yes, exactly.
Well, I just hear me out in terms of what we would suggest is some other form of wording whereby we make clear that the defendant doesn't consider that the personal guarantee is enforceable against the claim. That's conceded. But based on the pleaded cases,
well, it's unenforceable because it's void ab initio and of no legal effect. Do you disagree with that?
Well, the point I'd make on that is that there are pleaded issues as to what was the applicable law in this case as to the consequences of the if the signature had not been signed by the claimant, and then based on that applicable law, even if the signature was not of the claimant, what would be the consequences of the validity of the document? And it on the pleaded cases, it did not necessarily follow, does not necessarily follow that the making of that admission renders the contract null and void. But that's not to understand, I'm emphasising not to say that we're saying that the personal guarantee is in some way enforceable.
Let me take it in a positive way. Do you agree? Sorry, you have admitted and you accept that, and the court will declare that the guarantee or the document title personal guarantee was not signed by the claimant. Do you agree that it follows that the document on the purported personal guarantee is void ab initio and of no legal effect?
Well, I think I submitted at the outset that we in the circumstances of this application, we wanted more time to consider our position on this. But what we're saying now is that what we think that's needed all that's needed in the order is that the bank will not pursue the claimant on the personal guarantee.
No, I think that's been raised before and was not acceptable to the claimant. The claimant is not satisfied with the bank's assurance that it will not pursue the guarantee. The claimant wants the legal position set out in the declaration. So the question is not what does the bank intend to do or not to do, but what is the legal rights which flow from the fact that the claimant did not sign the guarantee. And the claimant says it follows from as a matter of law, from the fact that the claimant did not sign the guarantee, that the purported guarantee is void and of no legal effect. Now, my question to you again is, do you agree or disagree with that?
Well, as I say, what I've said is that there are pleaded issues on that point. Those pleaded issues haven't been resolved. It doesn't follow from the contents of the letter that would be the legal consequence. However, I'm aware that
I'm sorry, I'm on loss here, Mr. McCarthy.
Yeah.
Can you
well, I
tell me?
won't, Your Honour, you're against me on this, and I won't push the point any further if
All right.
That's the case.
All right. Well, the form of the order will be, the second form of the order is that accordingly the said personal guarantee is void ab initio and of no legal effect. That takes us to the question of costs. I'll go first to Mr. Osman. Mr. Osman, you have filed let me see if I can find it.
The cost statement.
Before I get yes, you filed a cost statement. You've also filed a witness statement of Carlo Ferragoli, and you filed a skeleton argument.
Yes.
Now, is that as much as you wish to rely upon for the order you seek for indemnity costs?
Yes, it is.
I should tell you one matter that troubles me generally with the form of the statement of costs. I know you're following the court precedent, the form provided, but this, I'm afraid, is a problem that I have in many, if not most cases, and that is it tells me nothing about what was spent on each part of the case or when. Now, what I'm foreshadowing here, Mr. Osman, is that I'll start again. I anticipate from what Mr. McCarthy has said that the defendant will want time to respond to your application in relation to costs, and I will give the defendant that time. Subject to what the defendant might say, it is unlikely that, I'll go back a step. It is likely that I would determine what cost order should be made. I think it follows that the claimant should have his costs. Mr. McCarthy might say otherwise. There is a question of whether that should be on the standard basis or the indemnity basis. I will determine that issue. At the moment, it's unlikely that I would make an immediate assessment of the costs.
I see.
Essentially for the reason that I've said to you, I find these statement of costs to be unhelpful in telling me what was spent, what work was done, and how much time was spent on each aspect of the case, which makes it makes me unable to determine whether the amount spent was reasonable, the work undertaken was reasonable, unreasonable in amount, because I simply can't tell from the statement of costs what was done doing what. Now that is why, except in the simplest of cases, I will usually order that the costs be assessed. Now, I'm not inviting you to, as it were, undertake a form of assessment in front of me. It's simply why I will ordinarily, except in the simplest of cases, make an order that for an assessment in the way the rules set out. Is there anything you want to add to all that, Mr. Osman?
No, I don't want to criticise those who put these precedent forms together, but can I say this lightly? I think in my experience in England as a jurisdiction, these forms look somewhat different for this exercise.
Yeah,
that's probably all I need to say about that. But this is the form, so this is what was done, and I hear Your Honour in that regard. I don't understand Your Honour to be saying that you're ordering detailed assessment. I think, if I may, what is being suggested is a bit more detail to back up this particular form, which is not the same as detailed assessment. It's just giving more information to give you a better understanding of how the headline figures are put together.
If you did, then that might cause me to make an assessment, to myself make the assessment rather than sending it off to the registrar. But that's,
I see.
That's what I'm raising. But it may be that it's just as efficient to send it to the registrar, because otherwise we're just doing the same steps, but before me. But that's why I raised the point of view.
No, I entirely understand. There are 2 points that flow from that then, and that's that I would invite you to make a determination today regarding the principle of assessment, i.e. standard versus indemnity. And forgive me for trespassing on your thoughts, I believe that's what Your Honour is moving towards.
No, I don't intend to do that today, because I was going to say, I'm sure Mr. McCarthy wants time to respond and he hasn't had it.
I think that's fair enough. I can understand that. I put in submissions, and I put in, Mr. Vedragoli's put in some witness evidence. There is a question that flows from that, though, and that's that I said the decision as to whether it's on the standard or indemnity basis.
I think I'm probably confused you. Let me indicate to you my present intention. I would presently intend to make an order that the defendant have, say, 14 days in which to put in any witness statements and outline of submissions in response to your submissions. I would then propose, subject to what parties have to say, to make a decision on the papers as to what the appropriate order for costs should be. Provisionally, my intention, which I'm flagging to you, is that I would determine first whether the cost should be on the standard basis or an indemnity basis. Secondly, whether I should make an immediate assessment or order that the matter go to an assessment before the registrar. Currently, my thinking is it should be the latter, because I'm not in a position to undertake that assessment of whether the costs have been reasonably incurred and reasonable in amount. The third issue I would then undertake is that you seek a order for costs on account, and I would then make a determination on that.
Yes. Oh, in that regard, and thank you. I probably confused myself. That seems to be the if I may say, sensible way to deal with it, because I recognise that the learned friend hasn't had an opportunity to respond to my written submissions or Mr. Ventrigoli's evidence, and it's not right. We must have an opportunity to do that.
All right. Well, then the third order I propose then is that the defendant file and serve any witness statements and an outline of submissions in relation to costs within 14 days, or I think it's better I say by
date, please.
Yeah, what does 14? That's 33. Is that the 3rd of October?
I make that the 3rd.
Yes, by 3 October. Or would you want to respond to that, Mr. Osman?
I'd like to have the option to respond because I don't know what's been going to said.
Yeah. The claimant file and serve any responsive witness statements and submissions by how long? Another 14 days? 7?
I think I can do it 7.
By 10 October 2025. In order 3, when I was saying the defendant file, I used the words outline of submissions. That should simply be submissions. So the orders that I'm proposing: 3, the defendant file and serve any witness statements and submissions in relation to costs by 3 October 2025. 4, the claimant file and serve any responsive witness statements and submissions by 10 October 2025. 5, the court will determine the orders as to costs on the papers.
Yes.
Yes, Mr. McCarthy?
Yes, we're very grateful for the opportunity to respond.
That's procedural fairness for you, Mr. McCarthy. All right. So is there anything else?
I don't think so. Costs for today, but that can be dealt with in the round in relation to costs assessed going forward. Yeah.
Yes. Mr. McCarthy?
We just make clear that the cost, there's been some discussion about types of cost orders, etc. But what we're saying is the costs aren't dealt with in a fragmented basis, that it's all dealt with once we've had a chance to reply.
I'm not sure.
I don't quite understand that.
Can you spell that out?
Well, there was some suggestion that making whether any order would be made today. I just want to make clear that in relation to costs, the orders that have been made, just that those directions you've just given.
Correct.
Yes.
All right. Yeah. Well, thank you then. I thank you both and those assisting you and the court staff, and that concludes today's hearing. Thank you.
Thank you.